Are we proceeding with a contested hearing, or do you have an agreement?
We have an agreement, Your Honor. I don't believe that the father has been served, though, Your Honor. So I think that the orders will have to not include him.
Is that your understanding as well, Ms. Sioni?
It is, Your Honor. I had an agreement with him, with regard to the TFF, but I have not been able to meet with him since it was changed to removal.
Understood. All right. Okay, thank you. All right, Ms. Kyler Green, would you please begin the announcements?
Yes, Your Honor. Good morning. Emily Kyler Green, attorney for the department.
Jimmy Drozdel Mitchell, investigation supervisor.
Irving Santiago Chavez, investigator for the department.
Irene Acosta, attorney ad litem, appointed to represent the respondent mother, Brianna Sampson. I'm ready. Ms. Sampson, can you unmute and state your name for the judge, please?
Brianna Sampson.
Carol Sioni, attorney ad litem, appointed to represent respondent father Eddie Menchaca, who is not present.
Kendra Sims, attorney ad litem for the children.
Amy Harding, Hill Country Casa, guardian ad litem for the children.
Well, we're here today for an adversary hearing. My understanding is the parties have an agreement. Ms. Kyler Green, would you like to state the terms and conditions?
Yes, Your Honor. Thank you. The parties agree that the department be granted temporary managing conservator of the children and Ms. Brianna Sampson be temporary possessory conservator. We agree to hold an FGC at a later date to create family plans of service. It's my understanding that the mom is in the process, that Ms. Sampson is in the process of attending inpatient rehab. And so the department and Belong will make attempts for the services that she engages in at inpatient will I don't know, count, I suppose is the correct word, for services that we come up with at the FGC. Visitation, we can't really agree to that yet because it will depend on the facility of when and how visitation can work, but we'll make all efforts to have an agreed upon visitation schedule where her visits are supervised by the department. And the parties agree that the department and Belong will make attempts for the placement to remain so long as it's in the best interest of the children. But when and if it becomes not in the best interest of the children, those children can be moved. And the last portion, Your Honor, is daycare. The parties have requested for Belong to pay for daycare for Atticus.
Do the parties stipulate to the reasonable efforts made by the department as stated in the affidavit, with the exception of Ms. Sioni and Mr. Menchaca?
Yes, Your Honor. And Your Honor, also, I know this is typically just included in the order, but I wanted to make sure that the parties agreed that it's not an admission by mom. It's just she's agreeing to temporary managing conservatorship.
Other than that, Ms. Costa, is that your understanding of the agreement?
Yes, Your Honor. Yes, I would like to have the discussion regarding visits at the FGC. I don't know what the facilities requirements are with regard to visitation, but I'm sure that can all be hammered out.
Yeah, I'd made a note when Ms. Kyler Green was talking. I'd made a note to make an order that you all discuss based on the facility's capability of visitation agreement for supervised visitations. I generally want to enter an order at the adversary allowing for visitation, but I understand that is kind of up in the air at the moment. So I'm going to order that supervised visitation, but I'm also going to order you all to make sure that you come up with a schedule. All right, Ms. Sioni, I know you're not a party to the agreement at this time. Ms. Sims, is that your understanding of the agreement?
Yes, Your Honor.
Okay. Casa?
Yes, Your Honor, that's my understanding of the agreement as well.
Okay. Ms. Sansom, can you please unmute?
Yes, sir.
You heard the agreement that Ms. Kyler Green stated on the record?
Yes, sir.
Did you have an opportunity to discuss that agreement with your attorney?
Yes, sir.
Do you understand what the agreement consists of and what you're expected to do?
Yes, sir, I do.
All right. And were you forced in any way to agree to the terms?
No, sir.
Were you made any promises or given any inducements to get you to agree to it?
No, sir.
And are you asking the court to approve your agreement today?
Yes, sir.
And Miss Sampson was served, I show, July 19th, personal service. Court will take judicial notice unless you have a different date, Miss Tyler Green, but that's what I see.
That's the date I have, Your Honor.
Okay. All right. Mr. Santiago, do you believe that this agreement is in the best interest of the children?
Yes, sir.
Current placement safe and appropriate in meeting their needs?
Yes.
All right, let's get that placement information entered. What date were they placed in their current placement?
July 19th.
What type of placement is this?
Kinship,
What county?
Gillespie.
And what level of care are they?
Basic, I believe.
I'm sorry?
I believe it's basic.
Basic, okay. Thank you. Anything else I need to take up before I make a ruling?
Not from the department, Your Honor.
Based on the announcements and agreements of the parties for the purposes of the adversary hearing, the court finds that Mr. Menchaca has not yet been served. The court will grant Ms. Sione's not ready and enter no orders as to Mr. Menchaca at this time. Court will name the Department of Family Protective Services as the temporary managing conservator of the children. Court will name the mother, Ms. Brianna Sampson, as the temporary possessory conservator. At this time, due to the mother going into inpatient, the court will order the parties to make sure that there is a supervised visitation schedule for Ms. Sampson, subject to the capability of the facility in which she will be attending and whatever parameters are necessary. But I do want to make sure she gets those visitations. I'm going to order the department and the parties to attend an FGC, a family group conference, and create services. Generally, those are in person. If the mother is inpatient at the time the FGC occurs, I will allow her to participate virtually. If she is not yet an inpatient, then I will require the FGC to be in person. The court finds that the current placement of the children is safe and appropriate, meeting their needs and in their best interest to continue at this time. And the court finds that the placement will remain the same until it is not in the best interest of the children based on the agreement of the parties. I'm assuming the parties want to defer medical support and child support at this time.
Yes, Your Honor.
Yes.
An order belong to pay for daycare for Atticus. And find that the parties have stipulated as to the reasonable efforts made in the affidavit and that this agreement is in the best interest of the children. Court finds that there is sufficient evidence to satisfy a person of ordinary prudence and caution that there is a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal. And reasonable efforts have been made to enable the child to return home, but there's a substantial risk of a continuing danger if the child is returned home. Court makes that finding subject to Chapter 262.013, where the parties have agreed that the mother, by entering into this agreement with the department, is not making any admission as to the allegations in the affidavit. Will be a status hearing August 24th at 11 a.m. Ms. Sampson, I have to admonish you, the state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. In the event you cannot do so, your rights to your children could be restricted as they are now further or terminated. Okay. It's very important. I mean, I know you're kind of familiar with this process based on the TFF or the other case, but this is an issue where you have to do these things that the court's ordering so that you can be reunified with your children. And I'm really glad to hear that you're going into inpatient. Please stay in touch with Ms. Acosta, your attorney. Please use the resources that you're provided through the department and belong. And then also remember that CASA is there and can help you, as well as Ms. Sims, the children's attorney ad litem. Ms. Sims, is there anything else that you want to add at this time?
No, Your Honor, the kids are doing well. Placement is good.
Ms. Harding?
Nothing else to add at this time, Your Honor.
Okay. Well, thank you all for your time and your service and for working this agreement. We'll see you back August 24th, 2023 at 11 a.m.
Good
Ms.
morning, Your
Stanton,
Honor.
good luck
And
to you.
I'm sorry to do this again, but is there any way I can get a breakout room just to kind of see what's happening?
Oh, I suppose. We'll do room 1 again.
Your Honor, there is a Gabrielle Castro, which is my client, and her wife. They're using Gabriella Castro's feed, though, just for the record.
Yes, Your Honor. Good morning. Emily Kyler Green, attorney for the department.
Jimmy Drosna Mitchell, investigation supervisor.
Kara McElhenney, investigator for the department.
Carol McCata, family-based supervisor.
Jennifer Simmons, family-based caseworker.
Cecilia Howing on behalf of the mother, Laura Martinez. Ms. Martinez, can you please unmute and announce?
I'm Laura Martinez. I'm the mother.
Deborah Fuller, I was appointed to represent the children. I have a conflict in this case, Your Honor, and I have asked that I be substituted out and someone else be the ad litem for the children.
Okay, so in light of Ms. Fuller's conflict, what have the parties decided to do this morning?
Well, we have an agreement, Your Honor, with the understanding that Ms. Fuller has a conflict and the understanding that the court can and will appoint a new ad litem. But in regards to the mother, we have an agreement as to her services.
So Ms. Fuller's not part of the agreement?
I don't think she can be.
No, Your Honor, I previously represented Juan Lopez, who is the father of the twins. And I spoke with Ms. Martinez over the weekend, and we agreed that there was a conflict in the case, even though that was not a legal case. It was a pre-legal case.
I just wanted to make sure I understood that you weren't part of the agreement, that the parties were making this agreement without your involvement.
Correct.
All right. So in that sense, we don't have an attorney ad litem representing the children in the agreement. And I want to make sure that there's no objection by any of the parties that the children are not represented in this hearing, and that this agreement is without the children having representation. Is there any issue with that?
No, Your Honor.
Your Honor, I believe that because this is the pilot program, and we are going to do the PAT in-home parenting piece of this, I believe we can just get to the agreement and maybe send it to whoever gets appointed, and maybe do this as an order agreed to by all parties in writing, but at least get on the record what the details of that program would be.
I'm fine doing that. I just wanted to make sure that that was the understanding of all the parties before I entered any orders. So at this time, Ms. Fuller, I'm going to excuse you from the hearing. You're free to go. Thank you.
Thank you, Your Honor.
And let's go ahead and hear the terms and conditions of the agreement the parties have.
Yes, Your Honor, the parties agree for the mother to engage in the Parents as Teachers pilot program, to engage in individual therapy with Joni Chavez. And this is for both parents in the home, Your Honor. It's my understanding that right now the pleadings only have Laura Martinez, but it's agreed upon for both parents to engage in couples counseling and individual therapy. And these skills should be tailored towards parenting, protective parenting of these children. It's also agreed upon for these parents to engage in psychosocial analyses.
Where are the children? Are they home?
They're at daycare.
But they live in the home.
All right, Ms. Halron, is that your understanding of the agreement?
Not entirely, Your Honor. There is a father in this case. He is not part of this suit. He is the biological father, but my client has full custody. She is married to Gabriela Castro, who is the stepmother. So it will be mom and stepmother who are agreeing to work the services. I've spoken in depth with both Ms. Martinez and Ms. Castro, who are both agreeing to participate in services. As Ms. Castro is only the step parent, she is not a party to this case, but she is a willing participant in the services. The psychosocial would be to set up the structure and the goals for the therapy. And once the Ms. Martinez and Ms. Castro complete individual therapy, they would also complete couples therapy. The PAT program going in every week, but with the PAT program's emphasis being on protective parenting as opposed to, much more rudimentary parenting. My client has been a parent for some time, but they do have some concerns with issues that had occurred in the past in the home.
So when you said that it wasn't entirely your understanding of the agreement, you were talking specifically about the fact that there's a father.
Right. Both parents are not doing services. It's only my client. The father is not involved in this case.
I wasn't speaking of the father, Your Honor. I was speaking of the stepmother.
Yeah, I understood it to be Ms. Castro's or Ms. Castro.
Perfect.
Okay.
Just wanted to make sure that was clear. Sorry.
Okay. No, that's fine. Everything else is agreed.
Absolutely, Your Honor.
Okay. Ms. Martinez, you understand the agreement that's been stated here today on the record?
Yes, sir.
Did you have an opportunity to discuss that with your attorney, Ms. Halron?
Yes.
And were you forced to enter into the agreement anyway?
No.
Were you made any promises or inducements to get you to agree to it?
No, sir.
This is your voluntary agreement. You're asking the court to approve the agreement today?
Sure.
All right. Well, and again, this agreement would be made without the input of an attorney ad litem for the children. So the court's order today, Ms. Hellrung, if you could make sure that it states that the order will be forwarded to the substitute attorney. Ms. Greenlee, do we know who that's going to be yet?
Yes, Maureen Giannis.
Thank you. Okay. Then the court will adopt and approve the agreement of the parties. Ms. McElhaney, you believe this agreement is in the best interest of the children?
I do.
And you believe that the children are safe living with the mother at this time?
I do, sir.
Okay. The court finds that there's sufficient evidence to satisfy a person of ordinary prudence and caution that abuse or neglect occurred, or there's a substantial risk of abuse or neglect or continuing danger to the child's physical health or safety caused by an act or failure to act of the parent, managing conservator, guardian, or other member of the child's household. Family preservation services are necessary to ensure the child's physical health or safety, and family preservation services are appropriate based on the child's safety risk assessment and the child's family assessment. The court has reviewed the affidavit with the assessment. Ms. Hellrung, do you stipulate as to the allegations in the affidavit and the efforts made by the department?
I believe so, yes.
Okay. The court will take judicial notice of the affidavit and the stipulation of the parties that these services are necessary, and the court's order shall include and identify require specific services narrowly tailored to address the factors that make the child a candidate for foster care, include a statement on whether the services to be provided to the family are appropriate to address the factors that place the child at risk of removal. And the court will order family preservation services for Miss Castro, who is not the biological parent, but is living with Miss Martinez, is in a relationship with her, and court is not making any services as to the father at this time. The services shall include PAT, parents as teachers, individual therapy with Joni Chavez Martel, and psychosocial analyses for both Miss Martinez and Miss Castro. And then we'll make sure that this order gets to Miss Yanis so that she can review it as the substituted attorney for the children. We're going to have a compliance hearing or status hearing October the 11th, 2023 at 9:30.
Also, couples counseling was part of the agreement.
So ordered.
Thank you.
Anything at this time that I failed to do?
Nothing else, Your Honor. Thank you.
No, Your Honor, thank you.
Okay. Miss Martinez and Miss Castro, I want to make sure you understand this TFF Family Preservation Services case is an example of one of the least restrictive tools that the state of Texas has to help parents get services to address concerns to prevent the case from progressing to something more intense and severe as far as your parental rights go. So please take it very seriously. Please be in touch with your attorney, Ms. Hellrung, Ms. Martinez, as well as Ms. Yanis when she's on the case, and your caseworker, Ms. McElhenney. If you do what's ordered here today and you engage in these services and you take them seriously, then this case shouldn't last very long before we have a situation where we can dismiss. If the alternative happens and you don't engage and you don't take it seriously, then the case will last longer than it needs to and could potentially progress to another level. Okay. I don't want to see that happen. Nobody in this room wants to see that happen. We want to see the concerns addressed, see this be successful, and send you on your way. Okay. So please take it seriously. That's all I have. Again, we'll be back October the 11th for a compliance hearing. So in 2 months, actually almost 3 months, we should come back with a really good report of everything that you've accomplished. That's the goal. Okay. Thank you all for working this out. We'll see you October 11th at 9:30. If nothing further, all parties. Ms. Kyler Green, would you please begin the announcements?
Thank you, Your Honor.
Yes, Your Honor. Good morning. Emily Kyler Green, attorney for the department.
Jamie Drozda Mitchell, investigation supervisor.
Sandra Snow, investigator.
Irene Acosta, attorney ad litem, appointed to represent the father, James Luce. We're ready, Judge.
Mr.
Richard
Luce,
Saldivar, attorney. I'm sorry.
go ahead, Mr. Saldivar.
Richard Saldivar, attorney for the child. Ready?
Mr. Luce, could you please state your name?
My name is James Luce, father of Leland.
All right. Anyone who's not an attorney or will be giving testimony, go ahead, Ms. Rapson. Sorry.
Goldie Rapson, Hill Country Casa, guardian ad litem for the child.
Okay. All right, we're here for an adversary. Miss Kyler Green, do the parties have an agreement?
We do, Your Honor.
And do the parties all stipulate as to the reasonable efforts made in the affidavit?
We do, or they do.
All right.
Yes, Your Honor.
And Ms. Snow, there's no Indian child heritage in this suit, correct?
Correct.
All right. What are the terms and conditions of the agreement, Ms. Skylar Green?
Your Honor, the parties agree for the department to be named as temporary managing conservator of the child and for the father to be named as temporary possessory conservator. The parties agreed to hold a family group conference to form a family plan of service for the father. It's my understanding that the biological mother, Your Honor, just for the court's awareness, her rights were terminated previously. The parties also agree that the father's agreement to this 262 is not an admission to the allegations made against him. The child has requested no visitation, so the parties agree that there will not be visitation at this point. The child right now is not placed in a foster home, but the Department and Belong will continue to make efforts for a more suitable placement for him.
Is he in shelter?
Yes, Your Honor.
Ms. Snow, what day was he placed there?
7/15 of 2023.
What county is that in?
Kerr County.
Do you believe his placement is safe and appropriate, meeting his needs at this time?
Yes, sir, I do.
Is it in the best interest of the child for him to remain there until you find another placement?
Yes, sir, it is.
Ms. Acosta, is that your understanding of the agreement?
Yes, Your Honor, it is.
Mr. Saldivar?
Yes, Your Honor, it is.
Casa?
Yes, Your Honor.
All right. Well, he's 16. Anything that we need to discuss as far as, his age and being in a shelter that you all haven't talked about already?
Judge, he did mention that he has a sister in Kerrville that he wants to visit with. So if the department can reach out and see if that can be set up for him. I believe she's 6 years old and he wants to maintain contact with her if possible. There are family members in Florida that he wants to be studied. So his goal is to live with the family members in Florida if they're appropriate.
Mr. Luce, did you hear the agreement?
Yes, sir.
Is that the agreement you made?
Yes, sir.
You had a chance to discuss it with Ms. Acosta?
Yes, sir.
Do you understand what's expected of you?
Yes, sir.
Were you forced to enter into this agreement in any way?
No, sir.
Were you made any promises or given any inducements to get you to agree to it?
No, sir.
Are you asking the court to approve the agreement today?
Yes, sir.
All right, let's just get into your indigency real quick. I've read your indigency affidavit. Has anything changed since you sent this affidavit in?
On my part?
Yes.
No, sir.
And is it your testimony to the court today that you cannot afford an attorney?
Yes, sir. I cannot.
And do you have anything saved up or any money available that you could use towards an attorney?
No, sir. I used all of my money to bail myself out of jail.
Okay. Do you have anything at this time that you could sell that would allow you to have the money for an attorney?
No, sir.
At the end of the day, when you pay all your bills, or at the end of the month, do you have any money left over that you could use for an attorney?
At this time, I don't, because I still owe the Bell's bondsman money.
Okay. We'll find you indigent for the purposes of this suit and maintain Ms. Acosta in her appointment.
Thank you, sir.
You're welcome. My understanding from reviewing of the affidavit, Ms. Snow, is that there is nobody else that could take placement at this time. No other family member, correct?
Correct.
Okay. All right, then at this time, the court will find there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal. and reasonable efforts have been made to enable the child to return home, but there's a substantial risk of a continuing danger if the child is returned home. Court makes that finding, and also with the caveat of 262.013, that by agreeing to the temporary managing conservatorship of the department, Mr. Luce is not admitting any of the allegations in the affidavit. The court will find there's no Indian child heritage in this suit, that Mr. Luce was served in this case by waiver of July 19th. Court will name the Department of Family Protective Services as the temporary managing conservator. Will name Mr. Luce as the temporary possessory conservator, or makes the finding that the biological mother's rights were terminated by a prior suit in 2019. Court will order the parties to hold a family group conference to develop family plans of service that are narrowly tailored to address the concerns that brought the child into the care of the department. Court finds that at this time, per the child's request, there will be no visitation. I'm going to order the parties to continue to revisit that as we move forward. And I'm going to order that the child be in therapy to discuss contact with his father and domestic violence as we move forward. I know you're going to make some other services, but I want that to be a specific service.
Yes, sir.
Maintain him in his current placement, find that it's safe and appropriate, meeting his needs, and in his best interest to continue until a more appropriate placement is found. I am going to order belong to look at sibling visits with the 6-year-old. I understand that he may not be able to make it work because the other parents or guardian has to agree to it, but something we can consider, and also to study family members in Florida. Our next hearing is going to be our status hearing. That's going to be September the 6th, 2023 at 11 a.m. I have to admonish you, Mr. Luce, that the state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. In the event you cannot do so, your rights to your child are subject to restriction and or termination.
Yes, sir.
Thank you all for working out this agreement this morning. And Mr. Luce, just stay in touch with your attorney, Mr. Costa, also your caseworker, and CASA can also help. Mr. Saldivar represents your son, and your attorney, Mr. Saldivar, can certainly help facilitate any appropriate communication. There will be a therapist involved, so any contact that you have with the child is going to have to be approved. So don't fall into the trap of figuring out how to contact your son under the table. Like if he contacts you on social media or something like that, you need to let your attorney know, because right now there's no contact. Okay. I don't want you to get in trouble for something that Leland does. Okay. All right.
Yes, sir.
Well,
thank you all for
I
your time.
suppose just to get organized, Your Honor, I think just to let the court know, I think the parties are going to be in agreement to request a pre-262 mediation, but I also think there's like issues with conflicts that our attorneys are going to need to be substituted out. So I don't know how we want to skin that cat.
Let me call the case and let's get everything on the recording. Ms. Kyler Green, would you please begin the announcements?
Yes, Your Honor. Good afternoon. Emily Kyler Green, attorney for the department.
Matthew Schaefer, family-based caseworker.
Joe, permanency specialist.
Gracie DeLuna, CMO for the department. Cecilia Howard on behalf of the mother, Marisol Reyes. Ms. Reyes, can you unmute and announce?
Marisol Reyes.
Hi, Irina Costa. I was appointed to represent the respondent, Father Angel Alaquines. Your Honor, I'm announcing not ready for 2 reasons. 1, I haven't had contact with Mr. Alaquines, and 2, I believe I have a conflict. I represented a mother who is an adverse party to Mr. Alaquines in a different case. I recognized the name, but it didn't click until maybe yesterday that the reason why the name sounded so familiar.
Understood.
Alana Pearsall, attorney. Oh, I'm sorry, Deborah, go ahead.
Deborah Fuller, attorney and guardian ad litem for the child. Your Honor, I also represented a mother in a case against Mr. Alaquines. I don't feel like I have a conflict because we were adverse to him at that time and were adverse to him at this proceeding, but I did represent a mother where Mr. Alakenya's rights were terminated.
Okay, did you announce ready or not ready?
I'm ready, Your Honor.
Okay.
Alana Pearsall, attorney for intervener, who is present, and we are ready to proceed to the 262. Ms. Peralta, can you introduce yourself, please?
Yes, Janelle Peralta, caregiver for Raina.
All right. I do believe Miss Acosta, having represented a prior client adverse to the interest of her own client, is a conflict. Ms. Fuller, the only question I would have for you, you have a prior affiliation, which in and of itself is not a conflict, but my question to you would be, do you feel like you have any information or any type of unfair advantage as a result of your previous representation that would that you wouldn't have normally in this case had you not represented that person?
No, Your Honor. I mean, he did not appear in that case. He was incarcerated at the time, so I didn't have any really. He didn't participate in the services, and so my client had a previous court order, and then he was terminated.
Okay. Well, I don't think. I mean, it sounds like your alignment is the same, so that's not an issue. And if you didn't receive any information throughout the course of that representation that would give you some sort of unfair advantage here or cause any kind of ethical quandary, I don't think you have a conflict. But if anybody else feels as if a conflict exists, I'm happy to hear whatever you might have to say. Is there anyone else that believes Ms. Fuller might be in conflict?
And Your Honor, because I haven't spoken to Mr. Alakinas, I wouldn't be able to say whether or not on his behalf he would think that there was one.
Right. Well, I just believe from what you said that there's definitely the potential. So I wouldn't want to put you in that situation. That being the case, Mr. Schaefer, do you anticipate there being any placement issues if the court were to reset this adversary and send the parties to a 262 mediation? Any safety issues with the kids?
No, sir. Not at this time. Nothing.
The child, excuse me. And the child can continue in the current placement without any issues?
Yes.
Okay.
But Your Honor, I do agree that there are safety issues. There was a recent incident in regards to the mother and attempting to either remove the child from the placement's car or at least be very aggressive with the placement. And that just happened, I think, on Friday evening. So I'm concerned if you could just admonish the mother about her not approaching the placement and attempting to take her child.
Judge, and I agree with that. So I don't think this
Hang
child
on,
would be.
Ms. Reyes. Ms. Pearsall was speaking.
I don't think this child would be safe absent an extension of the temporary restraining order. So I'm asking that be extended because otherwise I don't think this child is safe. 1, 2, Judge, I don't think a pre-262 mediation will serve any purpose in this case. I've talked to multiple parties and honestly, there's just no room for agreement. So I quite frankly think it's a waste of time and I don't think it's necessary. I would ask that we proceed to the 262, at least against the mother. I understand that of course they have the conflict, so we may have to reset it as to that. But there is absolutely no purpose to the mediation.
Okay.
Your Honor, if I may, Marisol, let me speak. I do believe that there is a purpose. I would like to at least discuss. I appreciate Ms. Pearsall's position, but they're an intervener and we do have an agreement for a pre-mediation 262 with both the department and the ad litem to discuss.
Right.
And Your Honor, one last thing. We're we would like to request that you take judicial notice of Ms. Reyes' presence here and not have the department fulfill its need to personally serve her.
Okay. Is any party going to, and I know you can't really participate in this, Ms. Acosta, but is there going to be any objection to the court continuing the emergency orders? Because, you know, I'm kind of in between a rock and a hard place. I've only got so much time I can extend it unless all the parties agree in writing. And I am out of the office Friday for a week. And then we're not coming back for a little bit on a Medina case. So it's going to be some time before I'm able to hear this adversary hearing, which is why I was asking about placement. So is any party going to object to the court resetting the adversary hearing outside of the statutory timeline?
Well, I guess it depends on whether we will have the extension of the TRO in place, Judge.
Well, that's what I'm talking about. That's exactly what I'm talking about. Is I can't reset the case without an extension of the TRO. Does that make sense?
I'm in agreement with that, Your Honor.
Okay.
I mean, honestly, Your Honor, if we can attempt mediation, I think I have spoken to my client regarding the concerns of what happened. And I think she is aware that the department now has temporary managing conservatorship. So I believe if the court extends the temporary order, the temporary emergency order, then my client will follow.
And you'll sign for her in writing?
Yes, sir.
Okay. Well, I understand that the intervener's position is that mediation may not be effective, but I'm going to order it to a pre-262 mediation anyway, because we all know that mediation sometimes has the ability to find solutions where parties believe no solutions may be found. So I will grant Ms. Acosta is not ready and order that she be substituted. Ms. Greenlee, who would be, well, Ms. Greenlee needs to look at, so here's the deal. Usually Ms. Greenlee is able to run a conflicts check prior to any appointment. But for some reason on this case, when she pulled the names, she didn't get this, and it's more than likely because it was some other case that didn't come before us, but there was an affiliation there. So that's probably why we don't normally have conflict issues like this. Ms. Harris represented Mr. Martinez prior to this suit. So I don't know, can anybody think of any reason why Ms. Harris would not be able to represent him in this suit?
No, Your Honor.
I have no objection to that. No problem.
Well, Ms. Greenlee, unless you see some issue, I think it would be appropriate to substitute Ms. Harris for Ms. Acosta. And Ms. Acosta, you are excused from any prior.
I don't see any issue. And I think the problem I was running into with looking him up was that timeout that I've been trying to get fixed. And it's just, they've acknowledged it. They just haven't fixed it. So it's hindering me to look up people by just their name and the information we have from the jump.
Understood.
Your Honor, we're also, I'm having my legal assistant look up any case numbers that we can find as well to help the court out.
Okay.
Awesome.
Well, I think what Ms. Greenlee's talking about on our end is our software has been experiencing a timeout issue on searches. So there's a lot of cases for the search to process. And when you're searching and you don't have specific parameters to narrow that search, it takes it a while. And we're running into an error where the system times out before the search is completed. So that could have been part of the issue too. All right. So then I'm going to order the parties to a 262 mediation. I'm going to reset this based on the agreement of the parties to August. What did you say? August 25th, Ms. Greenlee?
Yes, August 25th at 10:30.
August 25th at 10:30. That's the earliest I can give you. We just don't have anything else in between now and then. And order the pre-262 mediation, substitute Ms. Harrison, and continue the emergency orders and order all the attorneys to sign that order based on the agreement of the parties.
Your Honor, can you order that Ms. Reyes has to be present to the mediation?
I'm going to order that Ms. Reyes is present. Ms. Reyes, if you're not present for the mediation, you will be in contempt of court. That's a court order for you to be there. I'm also going to order or admonish Ms. Reyes that there's to be no contact with the placement or the child at the placement outside of what's allowed and what's already been ordered. Any visitation or contact that the department is allowing you, you may have that. If there's anything outside of that, that's contempt of court. That's not allowed. Do you understand me, Ms. Reyes?
Yes.
Your Honor, I'm not aware of what the visitation schedule was under the family-based case and what it is under the emergency order. So if I could just get that on the record so both she and I are aware of it.
Yes, Mr. Schaefer.
Yes, sir. So the visitation in the family-based case was happening twice a week for an hour long, supervised by the department. Used to be in public places, but then we were able to relocate to Reyes daycare in an adjacent unoccupied building, which helped out with the conditions of the heat and everything. It was more suitable for the child. So those visits were occurring, like I said, twice a week for an hour long at the daycare. At this time, we just keep it standard with the removal of twice a month for an hour long, and supervised at the CPS office.
Your Honor, could we have it weekly since it was twice a week? I don't want to cut it off to twice a month. That would only allow her to have 2 visits.
Well, Judge, and I think to get a true representation out of when she could have had it, but when she actually had it, Mr. Schaefer, can I ask you how many times a month mom actually saw the child?
Mom, for the most part, was pretty consistent with attending the weekly visits, but towards the end, it got a little sporadic where maybe out of the 8 visits a month, she may have had about 5 or at least half.
Which would be the standard twice a month, so at least 3 times a month anyway, Judge. So I would ask that, they're asking for a reset. We're all ready to go forward. There's no reason to expose this child to mom, who the court is aware is continuing to use meth. So I'm asking that we do it twice a month.
And Your Honor, as the ad litem for the child, as long as they're supervised at the CPS office, I have no issue with once a week. And we can address it. If she starts missing visits, we can address that.
That was my inclination, was to order that it be once a week for an hour, supervised by the department at the CPS office. And if mom misses a visit, then it goes back to twice a month. So what that means, Ms. Reyes, if you looking at the calendar here, that gives you between now and the 25th, four potential visits that if you miss one, that's going to go down to 2. I mean, I agree with Ms. Pearsall. If you're missing visits, then there's no point in ordering that they continue every week. But Ms. Fuller has a point as well that if it's in the child's best interest to visit with you, then I'm going to allow those visits to go forward. And it's really important for you to realize that if Reina's attorney is saying it's in her best interest to have a visit with you, you better be there. It doesn't say much for your interest in doing the right thing here if you know that a visit for your daughter with you is in her best interest and you don't show up. So whatever else you have going on, it's lower in priority to this visit with your daughter. You got to make that happen. Okay. And that may be difficult with work schedules and things like that, but Mr. Schaefer is a very reasonable person and I think you can work it out. All right.
Your Honor, service issue, please.
I will find that by appearing here today, Miss Reyes has entered an appearance for all intents and purposes, and that she has agreed through counsel to 262 mediation and a reset of this case and extension of the emergency orders. Anything else that we need to take up?
No, Your Honor.
Not from the department. Thank you.
Okay. Well, thank you all for your time and service. Ms. Reyes, good luck to you and make sure you make those visits. And I'll see you all back on August the 25th at 10:30 on this case.